Welcome back to the deep dive. Today, we're getting into something that's, well, it's right at the intersection of law, public health, and frankly, personal tragedy.
We're talking about medical negligence specifically in Florida.
Right. We're focusing on the Florida Wrongful Death Act, and even more specifically, one little piece of it, statute section 768.218.
And that one subsection has been a legal lightning rod for, decades now. For so many advocacy groups, getting rid of it, repealing it, is the absolute #1 goal.
Because they see it as the key to justice.
Exactly. They believe it's the only way for families who lose a loved one to get what are called non-economic damages. So that's compensation for things like, pain, suffering, the loss of companionship.
Okay, let's stop right there, because the source material we're looking at today, it makes a really contentious point right from the start.
It does.
It argues that this entire decades-long fight is based on a critical misunderstanding of what justice even means here.
That's the core of it. And that's really our mission for this deep dive, to unpack that misunderstanding, to explore why focusing so narrowly on just financial compensation for grief might actually be holding us back from real accountability.
From protecting the public.
From protecting the public. And this is the key thing you, the listener, need to grasp. The statute only restricts financial compensation.
That's a crucial distinction.
It is. The source is very clear. It does not restrict professional accountability. It doesn't stop the state from investigating or disciplining a provider. The barrier is purely monetary.
So we're really talking about two different things. A system that writes a check.
And a system that, for lack of a better term, cleans house. If you think a big lawsuit is the only way to hold a dangerous doctor accountable, you might be confusing those two goals.
So let's get into the mechanics of this law.
Subsection
8. It sounds so sweeping, but how narrow is its actual application?
It's incredibly specific, and that's a detail that, often gets lost in the conversation. It really only applies in two very distinct situations.
Right.
The first is when the person who died was an unmarried adult and had no minor children. The second is when a parent dies, but all of their surviving children are already adults.
So if you're a single adult and you lose your elderly unmarried mom to medical error, or if you lose your adult unmarried child, you are barred from getting any damages for that emotional loss.
Correct. The law might recognize economic loss, medical bills, things like that, but it puts a value of 0 on the loss of that relationship.
And that's what leads directly to this misunderstanding, the source flags, right?
Precisely. Because those families feel so wronged, and they are, the public conversation then equates that entire fight for money with the concept of accountability itself.
And what are the real-world consequences of that misconception, beyond just frustrating those families?
The analysis points to 3 huge systemic problems. First, we just conflate getting a check with achieving justice.
Money equals justice.
Right. Second, this intense focus completely overshadows the state's actual disciplinary systems, the ones that are supposed to be protecting all of us.
And the third one sounds, almost like a self-fulfilling prophecy.
It really is. It creates this false belief that the state of Florida, its agencies, they cannot act against a bad doctor or a bad hospital unless a big lawsuit is filed and won.
It makes it seem like the regulators are just sitting on their hands, waiting for a lawyer to give them permission to do their job.
But the truth, as the source insists, is the opposite. Civil litigation gives compensation for something that already happened, but it's the Board of Medicine. It's the Agency for Healthcare Administration, AHCA. Those are the systems that are supposed to provide accountability and prevent it from happening again.
This brings us to a concept in the paper that's really critical for you to understand. It's this framework of the 2 doors of justice. Let's start with the one everyone is fighting over. The one subsection 8 guards, transactional justice.
Transactional justice is basically the civil court system. It's all about looking backward. It's retrospective. Its job is to compensate survivors and really to put a dollar amount on private grief.
But I can see why a family would want that. It feels like the only tangible power they have. They get their day in court. They get validation. Why isn't that enough?
Because the limitations of that door are just profound. A civil court victory, even a massive one, is just a transaction. It moves money from an insurance company to a family.
But it doesn't change anything else.
Nothing. A civil court absolutely cannot revoke a medical license. It can't restrict a doctor's practice. It can't order retraining for a whole hospital. A doctor who's found liable in a $10 million verdict can pay the insurance premium and be back at work the next day.
So the verdict validates the family's grief, but it offers 0 guarantee that the next patient is safe.
Exactly. It comforts the living, but it doesn't correct the cause of death. which brings us to the second door, instrumental justice.
And this is the door that promises real systemic correction.
It is. This door is forward-looking. Its only goal is to fix the system that allowed the death to happen in the first place, to protect future patients. It treats a preventable death not as a private financial issue, but as a public safety failure.
So what's behind this door? What actions are we talking about here?
We're talking about license sanctions, removing a doctor from practice, mandatory public reporting, real investigations by AHCA into hospital failures, and forcing them to reform their policies. This is the door that's supposed to enforce public safety.
And this is where the source points out that huge
A
contradiction.
huge mismatch, yeah.
Families and advocates, they describe what they want as instrumental justice. They say, we want accountability. We want to make sure this never happens to anyone else.
But their actions, their legislative energy for 35 years, has been almost entirely focused on repealing subsection 8. That's a purely transactional goal.
So that fight for money has just sucked all the oxygen out of the room for the fight for safety.
That's what the source argues. It's led to a kind of legislative paralysis on real accountability reform.
Okay, so we have this crucial accountability door, instrumental justice, that's wide open, it's untouched by subsection 8, but it's weak and nobody's using it. Why? Why are Florida's accountability systems so fragile?
Because they've been starved of political attention, of energy, of any real push for reform. While everyone's been fighting over civil litigation, the agencies actually tasked with public safety are left with high hurdles to clear, not enough funding, and penalties that are basically just a cost of doing business.
Let's start with the Board of Medicine, the Bell of Balm. They have the power to discipline doctors, but the source says they're weak. Tell us about these high evidentiary thresholds. What does that mean for you or me?
It means it is often way, way harder to prove negligence to the Board of Medicine than it is in a civil courtroom. The standard for them to act might be clear and convincing evidence.
Which sounds tough.
It's a very high bar. In a civil trial, you just need a preponderance of evidence, basically just over 50%. So that higher bar lets a lot of negligent practitioners escape any real professional consequences, even if they settle a bunch of lawsuits.
And what about their ability to even investigate? If the public thinks the only thing they can do is sue, they might not even file a complaint with the BM in the first place.
That's a huge part of it. The BM is often overwhelmed, understaffed. They can't conduct thorough, timely investigations. So if the investigations are slow and the bar for discipline is sky high, the system ends up protecting the provider, not the public.
Okay, what about AHCA, the Agency for Healthcare Administration? They're supposed to be the hospital watchdogs. Why are their penalties so toothless?
It really just comes down to basic economics. AHCA doesn't do audits very often, and when they find a hospital isn't complying, say they fail to report a serious adverse event, the fine is tiny.
A slap on the wrist.
Exactly. So if the fine for not reporting a death is, say, $10,000, but fixing the systemic problem that caused the death costs $100,000, what's the hospital going to do?
Pay the fine and move on. Which means the failure just sits there waiting to happen again.
Precisely. The penalties aren't strong enough to force them to make expensive, meaningful reforms.
And it's not just the state agencies. The source also points to internal systems, like hospital peer review and mandatory reporting. Why are those failing too?
Peer review is tricky. It's usually shielded by confidentiality, and it's full of conflicts of interest. The people on the review committee might be colleagues, friends, people who refer patients to the doctor being investigated.
So the goal becomes protecting the hospital's reputation, not the public.
It can, yes. And the results of those reviews almost never see the light of day. So if you're a patient, you have no way of knowing if the hospital you're walking into has a pattern of sweeping failures under the rug.
That's that transparency problem.
It is. And mandatory reporting has the same issues. Vague definitions of what even needs to be reported, weak penalties for not reporting. The system is there on paper, but in practice, it's just weak and opaque.
And this isn't just an abstract policy debate. The author of the source material grounds this whole thing in a really powerful personal story.
They do. The author talks about the preventable death of their own mother. And at first, they were focused, as anyone would be, on the civil process, on that transactional justice. They felt a big verdict was the only way to get validation.
But that changed.
It did. Through that process, they had this realization that no amount of money, no verdict, was going to protect the next person. The money only helped their family.
And the real justice would have been fixing the system for the future. So the emotional need for compensation was real. But the public safety need was for stronger oversight, for real investigations, for sanctions that actually took dangerous doctors out of practice.
That shift in thinking from personal compensation to public protection, that's the entire argument of this paper.
So let's talk solutions. If the answer is shifting our focus from compensation to correction, how do we actually do that? How do we build up instrumental justice in Florida?
Well, the good news is there are models for this. The source points to Michigan, which focused on accountability reforms, not just expanding who can sue.
And it worked.
It did. They saw demonstrated reductions in malpractice claims, patient safety went up, and public trust improved. It proves you can do both.
So what's the roadmap for Florida? What are the actionable recommendations?
First thing, you have to strengthen the Board of Medicine. That means the legislature needs to mandate automatic investigations of any sentinel event, any unexpected death or serious injury in a hospital.
No waiting for a complaint?
No waiting. You also have to lower those evidentiary thresholds for discipline. And this is critical, require them to publish detailed summaries of their disciplinary cases so the public knows what happened and why.
And what about AHCA? Give them some real teeth.
Absolutely. The recommendation is for more frequent, unannounced audits, stronger tiered penalties for noncompliance, and they need to publish annual reports that name names, which hospitals were fined, and for what. Real transparency.
And that's the third pillar, right? Transparency. Giving Floridians the actual data to make informed choices.
Yes. We need a public, easy-to-search database of disciplinary actions, findings of negligence, and patterns of violations by hospitals. And here's a tough one. A requirement to notify patients if their doctor is currently under investigation for serious negligence.
Wow. That would be instrumental justice in action, protecting people proactively.
And this brings us back to the original fight over subsection 8. The source makes one final, crucial recommendation. Any move to repeal or reform that statute to expand compensation must be tied to these systemic accountability reforms.
So they have to be a package deal. You can't just get the money without also getting the safety reforms.
You can't let the compensation fight overshadow the correction fight again. They have to happen together.
So if we pull this all together, the distinction is really clear. Civil verdicts comfort the living. They validate grief. That's transactional justice.
But it's the accountability systems, the Board of Medicine, AHCA, mandatory reporting, those are the only things that can actually remove a dangerous practitioner, fix a broken system, and prevent future deaths.
Compensation helps one family. Instrumental justice protects everyone.
A preventable death should be seen as an expensive lesson. The response shouldn't just be a check for the family. It should be the immediate, top-to-bottom correction of every single system that allowed that death to happen. We spent 35 years arguing about the size of the check.
And it's time to open the second door. Which leaves you with this to think about. If true justice is defined by prevention, not just payment, and the political focus has been almost entirely on compensation, how do you make sure the legislature finally hears the demand for instrumental justice? Thanks for joining us for this deep dive. We'll see you next time.